Okay, hi everybody. Welcome to our Parent Guardian Speaker Series for the Down Syndrome Network of Montgomery County. Tonight we will hear about the 10 basic steps for financial planning. Our presenter is Jerry Hulick. We'll come back to that in 1 minute. As you all know, the mission of Down Syndrome Network of Montgomery County is to empower and support individuals with Down syndrome, their families, and the community through education, information, public awareness, and advocacy. A few housekeeping rules: please stay on mute during the presentation. We welcome cameras on so that everybody can see who's here. Please use the chat feature or raise your hand using the reactions tab located in the bottom menu to ask questions. For closed captions, click on live transcript and then show subtitles. Please keep your questions general, meaning this is not meant to be a session where you get advice on your personal situation. And I will return this link here to the chat at the end of our presentation, putting it in here right now so that I don't forget that, so that you can provide feedback about the presentation for us. And now let me introduce our speaker, Jerry Hulick, who I did not realize was the founder of the Washington Group Special Care Planning Team. I think we've all seen references made, referrals to that group on our list served through the years. Jerry has been providing presentations, consultation, advice, and services on special needs planning for decades. He does many similar presentations to nonprofit groups throughout the DC metro area. And we're very pleased to have him here tonight. Thanks, Jerry.
Thank you so much. So let me see if I can share. We can see the screen at this point?
Yes.
Very good. And we're just going to go, this is, in some respects, is fairly high level. Anytime we begin to talk about aspects of special needs planning, I mean, one of the constant questions I always get is, where can I go to find, all the information I need? And I wish I could say that there was some depository where all this kind of thing rests and you could go and you could get all those questions answered. But there's just so many different things that are involved in so many individual situations so that it varies very much. And the biggest thing we want to do is try to identify, the process that you can go through to at least, help with resource development, help with things that are out there, understand some of the sourcing of where you can get good information, and then just how does it all kind of come together in an overall plan. So let me move to the next slide. And now it's not working. Okay. This is the standard disclaimer that we have to use. I am not an attorney or a CPA, although I work with attorneys on a constant basis and work with CPAs, and basically anybody that's going to be involved in the center of planning or person-centered planning that we're doing for individuals. The planning has to include the whole family, right? It's not just about the special needs individual or a person with a disability. It's about the impact that it has to the caregivers, impact that it has to the rest of the family, and really understanding the dynamic of what the vision is for the future as a familiar unit. And so we will utilize anybody that we can in that process to build the best overall vision and plan for the future. So, that's what's important, I think, for most part, is caregivers are basically, taking care of a situation. In many families, that's going to be multiple people that might be doing it. I've got a lot of situations where the one spouse will be handling all medically related issues or therapeutic related issues, and another spouse will be filling out forms or going to find out about this program or attending workshops or whatever it be. And so when we talk about, caregiving, it's generally, again, not just necessarily one person. Do I have some situations with single parents? Absolutely. But at any given point in time, we need to understand the importance of that caregiver in the process and what it would take if that caregiver were not there or not around, and what the plan or vision is, what happens when they're not around. So that's a consideration that always has to be made part of this as well. We're talking about maintaining a lifestyle. So when we look at the future, the first step really, have we looked at the future? what are going to be the needs? And as we look at the existing resources that exist, we look at, whatever might be in the way of employer benefits that maybe parents or caregivers have that might affect the individual with a disability. If the individual with a disability is employed, how do the benefits that he or she receives from employment play into the overall plans? There's a lot of, independent in employment these days. I kind of look at employment for those with disabilities where we were with the educational systems 25 or 30 years ago. We've now had inclusion in many, many years in the school systems. The kids are coming out, the young people are coming out, and they want the same things that we all want. They want a good job. They want to maybe live independently. They want to understand transportation and issues. So as we look to the future, the vision has to include what we expect and hope to see happening. Will there be a need for these things that we see listed here, medical treatments or other additional education or skill development? Employment is opening up. It's not where we want it to be, but employment is opening up because the stereotypes that exist out there around capacity are changing because capacities are changing. The young people today are coming out more developed, more self-assured, and ready to do some certain things. Housing is a critically important issue. Is there going to be a need for independent housing? I have two very close friends with one of my planners who they were brother and sister in their 30s with Down syndrome. They wanted to live independently of mom and dad. Mom, not so happy about that. Dad, he was okay. And yet they didn't want to live together. They wanted to be separate. They wanted at least separate apartments. They could be in the same building, but they wanted separate apartments. They were crystal clear. I've done a letter of intent before where I was involving the individual with a disability in the room, and they said, could you please capture in the documents that I hate broccoli? Because he wanted well known that was an issue. So as crazy as that may sound, it's what is the lifestyle? What is that person wanting? How does that fit into the overall vision of what you're looking at? So all these things looking to the future are going to be very, very important. And it needs to be that specific. We don't need to be doing generic special needs trust or generic letter of intents or things like that. We want them to be specific around the needs and the desires and the vision for the person we're talking about. Oops, went one too far. Reviewing the beneficiary. So we have assets. We have employer benefits. And so the beneficiary arrangements, and in many instances when SSI is involved, we all know we have the means test. And we can't exceed the $2,000 or it will jeopardize SSI. There is so much focus on that, but today there's so many ways to work around that, either through a legal structure, able accounts, or things like that. And right now, recently, the legislation was finally introduced into the floor of the Congress to change the means test from 2,000 to 10,000. You are probably one group that is already well aware of that. But in any event, transfer of death, paid on death, transfer of death, let's say if you had a brokerage account as parents and something were to happen to either or both of you, then you can do something called the transfer of death, a TOD, which just lists where the funds in that brokerage account go if something were to happen to the primary owners. That allows you to list a special needs trust or to list others so that there's not a direct inheritance of monies that might somehow mess up the government benefits that are being received. Paid on death is what you typically see for bank accounts, savings accounts, checking accounts. These are all like kind of beneficiary arrangements that you would see in life insurance. But even in the employer basis, some people may have an HSA that's accumulating money in it for medical reasons. Well, if the employee were to pass, then those HSA funds are going to go to whatever is listed in their estate, and they'll pass as well. Group life insurance, 401ks, retirement plans, all of those come into play. We need to think in terms, may there be an inheritance come into play? Are the estate plans and the language and the various people that might leave an inheritance set up appropriately so the person doesn't receive the monies directly so that it can potentially mess up those government benefits? So all that speaks to not only setting in stage what is to take place, but also communicating what exists that allows others to maybe plan if they're planning on any sort of gifts or inheritance or life insurance or whatever benefit might come that would affect the individual. So those are all very important pieces. These days, We don't have an estate tax issue. In most instances, it's got to be a fairly substantial estate. So really, in many cases where we used to do a lot of estate planning with these things like TOD, POD, beneficiary arrangements, transference arrangements, we can really bypass much of what would normally be in probate and have monies set in stage so that it goes direct and it's not hung up by probate or any other aspect of settling a given estate situation. And that is kind of begins the integration of what we would do on the financial side with what we would be doing on the legal side and integrate those things coming together into a good plan. The family meeting, this is one of my favorite topics. We actually have a full-blown presentation on family meetings, getting families to communicate. Particularly as siblings are growing older, beginning to think for themselves. Everybody's thinking in terms of what may take place. That doesn't necessarily mean there's been any discussion around it. I have one of our clients is a clinical psychologist. He's meeting people daily, and he said he had to bring his family in to meet with us so they could have a discussion about what the future looks like. And I said, well, that's what you do for a living. He said, I can't do it with my own family. I have to get it facilitated. So this is a critically important piece because the more communication that's there, the less people are questioning what may take place. And the more we have all the resources of the family to say, this is the vision. This is what we think. I've done workshops with siblings who are going to be successor caregivers. They're not necessarily going to do it exactly the way mom and dad did it. They're going to, they're going to provide for the care, but it's not necessarily going to be exact. These kinds of things need to be discussed, the concerns, the future options, what everybody's vision is to make sure we're all on the same page. The future generations may not see some things as important as other things. So the more we communicate those things or even reduce it to the letter of intent or legal documents, the better chance there is that that's going to take place. So we look at 4, and that's creating a team. And this is a specialty area. So you'll find financial professionals. You'll hear them called special care planners. You'll hear them called chartered special needs consultants. That designation is through the American College, and it's an accredited college, an organization, and it's the same one that does CFPs, does CLUs. Most of the financial designations are done through the American College. They have a designation that's now been around for about 10 years that is the Chartered Special Needs Consultant. And that individual has been through more information about integration of financial issues, financial instruments, integration with legal plans, aspects of government benefits, and all that go into the government benefits, both on the public assistance side, SSI and Medicaid, as well as on the entitlement side of Social Security. So that's all part of it. Special needs attorneys, again, they exist out there. We have a lot of them in the Washington, D.C. area that specialize in special needs planning. And so that's important because we need to have somebody. I have just got a visitation by my lab. Sorry. We have attorneys, a lot of great estate planning attorneys. I've got an estate planning attorney I've used, but if I ask him, do you know about special needs planning? He would be the first to say that's not his specialty. So when you're in this place, we strongly encourage working with as many people that you can that specialize in understanding around disabilities, understanding around special needs, and making sure you're getting the appropriate and right answers when you're doing the overall planning. And that can include anybody in this circle that might be helpful. And again, establishing and creating what that vision may look like for the future. Additional resources, all the local nonprofits, NDSS and the local affiliates, they all have great resources that you can go to for information. There'll be newsletters, publications. There's many blogs that are put out by individuals within certain disabilities as well as broadly for disabilities. The government agencies, don't forget, many federal programs exist as well as state programs as well as county programs. And they're changing. I had my offices for a long time in Fairfax County, and we would get calls from the Fairfax County saying we have a new adult support program, but nobody knows about it. We don't have any way to promote it. Would you help us promote it? Because we have money to give and nobody is applying. And that changes. Situations change where there's new programs out there. We want to make sure we stay current. Sometimes it could be support for housing. It could be support for any number of different things that are out there. So, going and finding the support, working with the specialists that know this marketplace and know this community, that's going to help us really find the resources that are necessary. Step 6 is probably one of the most confusing things out there, the government benefits. On the left side, you see entitlement programs, and that's where we tend to think in terms of retirement at age 62 early, or full retirement these days around 67. Family benefits, if we look at statements, and they're not sending statements now out, but every 5 years. And then starting at age 60, they start sending them out every year. So we strongly encourage everybody to go online to SSA and establish your own personal account so that you can check your statement and check the values on that statement. Because when it comes to the family benefits that you see here, if you've got a child with a disability, they're going to be eligible for substantial entitlement benefits under the parents' earning records or whoever is caring for them. If there's a familial relationship or more than 50% of the support coming from them, it could be a grandparent, that they would then qualify for benefits from that person's Social Security entitlement benefits. These family benefits, the survivor benefits, and many of you heard before, DAC, the Disabled Adult Child, and or which is now called today the Children's Childhood Disability Benefit. The Social Security Administration loves to confuse things, so they changed the name from DAC to CD to Childhood Disability Benefits. But online, they refer to it at both if you go to ssa.gov. But that is a benefit that if the child is unable to have substantial gainful employment, then he's going to get a benefit from his parents' Social Security that while they're alive is going to be 50% of that benefit. This is that they cannot have substantial gainful employment. And after they pass, it jumps to 75%. If they've been on SSI, then Social Security is generally picking that up when they become eligible through a parent for the childhood benefit. And they're adult children, clearly, usually at that point. But they're picking that up now. They didn't used to, and they may not pick it up for a year or so. So knowing that that is a hugely substantial benefit that's going to be payable if you've got a disability situation where they can't have gainful employment. And so that's something to not miss, and something I always emphasize. In workshops I've done over the years, many people, if I go back 5 years, were not even aware of this as a benefit. So there's 3 life events that come into play, making it to retirement. And so a parent goes out on retirement, whether it be early at 62 or full retirement at 67. When they go out, then if there's a disability in the family, that individual may be eligible for benefits. That's the first life event, is meaning retirement. Second one is if a parent becomes disabled and there was another disabled child in the household, then that child's also going to be benefits from that parent. Or a premature death. My mother died when I was younger. My father didn't know any better. And so I was eligible for a benefit starting up until age 18, but my father didn't know about it. So she died when I was 11, and he found out about the benefit when I was 17. So I got it for 17, 8, and 18, and then I didn't get it. My brother never got it, who was several years older, and yet I could have been getting this benefit all along. So knowing the Social Security system and the section on your statement says family benefit, it gives you projections based on different things that could happen so that you can then see what that is. So as disability benefits, survivor benefits, the children disability benefit, these are all critically important, particularly when most planners that are out there today, even very good planners, if they don't specialize in this area, they will generally miss this as a possibility of significant monies coming into the household because they're just not familiar with the disability benefits. There tends to be a focus more on the retirement side. The public assistance benefits are just that. That requires some level of indigency with a disability. That's where SSI comes into play, which today is $900. We supply a lodging agreement to make sure that you get the maximum SSI, because if they see that there's not a housing arrangement of some kind for room and board, then some of the jurisdictions will cut back the SSI to about 2/3 of what the maximal amount is. So it's important to make sure that you're prepared when applying for SSI with the use of a lodging agreement and some of the other things that come into play. Social Security has now started doing a new thing where they look at a household and they say, we got 3 people that live in the house, so we're going to divide all the expenses divided by 3, and that's what you should be charging your son or daughter. And that's not even accurate, because the son or daughter with a disability may not be using all the household. Clearly, he's not using mom and dad's bedroom, or they're not using other aspects of the house. So we still try to quantify the usage of the house, and we still have Social Security accepting that as a valid calculation for qualification under SSI. Many people talk about getting, a denial first time into SSI. I think this is critically important as a child's getting near age 18. The family income is included in the calculation up until age 18. After age 18, it's just the child's. And so it's, getting prepped to know how to deal with Social Security, be consistent with it, know what to ask, and know how to present, and it's going to make all the difference in the world. Most of our clients, first time around, are getting their SSI and getting the maximum. So all the horror stories we hear them all the time. Most of it is because the family is not prepared to have that discussion with Social Security. Then you've got other public supports like you see right here. So these are, food stamp program, the SNAP program, those kinds of things, temporary assistance, and all that. But again, these are critically important to understand, to be part of the overall planning for the integration with the legal planning, to make sure that these benefits are being fully kept in line. Legal structure-wise, the letter of intent, you see this first bullet, it's really not a legal document, but it will be, if everything else is silent, will be looked at by the court for direction. So it's an important piece. In our industry, we almost like to call this a babysitter letter that you would leave instructions for the night, but on steroids. You want to capture everything here that is important to you for the caregiving of the individual we're talking about. If there's preferences, if there's certain things. We've had, letter of intents where I had one situation where they like peanut butter sandwiches, but if you put jelly on it, then it was going to freak them out. Or they had a situation where they start to act out, and if you put them into a warm shower, immediately calms them down. Those are critical pieces to know that not everybody, and you as caregivers, may take for granted, but not everybody's going to understand that. So the more specific we get, medications, connections, doctors, vision, all that kind of thing for a letter of intent is going to be important to the courts and to anybody that might need to refer to it. Guardianships and alternatives, really, we put this here not because it's necessary, but because it's a consideration. When they're turning age 18, they're their own person. And so we have to look at capacity and capability. We're not so much concerned. Today, we see more limited guardianship where we put protections into it. We don't take rights away. We just put protections in so that somebody, can't be harmed by someone else. I've had situations, family went into Costco. The daughter was, wandering around Costco and came back with a new cell phone because she went to the kiosk and signed up, and they had guardianship. They were immediately able to nullify the contract. I had one group home. All 6 of the guys in the group home walked to the local dealership, almost bought a car through the process. So they see parents, they see people using their credit cards. These days you can go online and get anything and everything. So a lot of these things is just, what is the capacity? What's the capability? Do we need to build in protections? Can they stand alone? All of these things are factors when looking at this. Your wills basically are directional items. They say this is what's to take place. Advanced medical directives, to the extent that everybody in the family can do them, it just really helps if there's any sort of an event where there's somebody's unconscious or incapacitated. And these days, they're much more specific because of the different cases we've seen around feeding tubes and things like that. The powers of attorney and those kinds of things, many of the legal documents depend upon capacity of the individual. So I might have somebody that maybe wouldn't be able to explain a trust document like a special needs trust, but they would understand a medical directive. And so we have a lot of our clients with adult children that have their own medical directives because they understand what it means. The attorneys doing it, or as officers of the court, only have to understand that the individual doing the document understands. So I think these are all things to come into play. The trust and all, we'll talk a little bit more about the different trusts, but the titling we talked about, all of these are kind of legal-based instruments that tie into the financial planning. And here you see at the bottom, the special needs attorney groups, the Academy of Special Needs Planners, and the Special Needs Alliance. They both have websites, and you can basically, on those websites, find out the attorneys that are specializing in this area of planning with special needs and disabilities that are in the Washington, D.C. area, whether it be Maryland, Virginia. Most of them, many of them practice in all three jurisdictions, and we've got some really good attorneys as a part of this group that are in this area. So special needs trusts, and what basically in simplified terms, a special needs trust is a trust that has language in it that you can put assets in and it will still preserve government benefits, meaning the public assistance type benefits like SSI or Medicaid or those kinds of things. Third-party trusts are simply set up by someone, parents as an example, for the benefit of the child. First-party trust is when it's their own money. So if a child got a settlement because of an accident or something like that, or there was an inheritance come through, that's when we would see the use of a first-party trust. First-party trusts have a Medicaid payback. So if the person's on Medicaid, they could literally come back if there was a residual value on the demise of the individual, and Medicaid can try to basically pay themselves back with the lowest common negotiated rate. So it's just an option when it's their own money. That's clearly, if you have a first party trust or their own money, we want to spend those monies first. Third party, we can accumulate. There's no payback. Anybody can put money into a third party trust. So it's much more flexible in that standpoint. Pooled trust is generally with a nonprofit where there may not be substantial enough assets to have a standalone separate trust. And so people will go into these pooled trusts. They'll compartmentalize everybody's money, but they get institutional management of the total sum so that they get better overall management. But the pooled trust then is going to be managed and compartmentalized for your component piece. Those can be very, very specific, and many of the nonprofits have other services, like they'll do some guardianship work, or they'll do attendant care, or they'll do certain aspects of management of a trust. So a lot of it just depends upon, again, the specific nonprofit, the various different pooled trusts, and there's hundreds of them across the country. The Special Needs Trust Fairness Act basically was a law that passed around the same time, around 2016, which just allows an individual with capacity to set up their own trust. It's also first party, but before, all these had to be set up by someone else for their benefit. We have a lot of wounded warriors that come back that have full intellectual capacity, but they were literally having to have somebody else set up a first party trust. So the Special Needs Trust Fairness Act allows individuals to set it up for themselves. Someone else has to be trustee to administer funds, but it just allows them a greater flexibility for the setup of their own situation. Usually this is also where I talk about ABLE accounts. In all the planning that we do, we strongly encourage, it's not an either or. We see special needs trusts many times done in conjunction with an ABLE account. In ABLE accounts now, you can put up to $17,000. Any number of people can gift that. ABLE accounts in the state of Maryland, there is no Medicaid clawback, where when it first came out there was, but Maryland passed legislation that they're not going to retrieve Medicaid from it, so it creates some flexibility there. It accumulates on a tax-favored basis, and it comes out, when it comes out and is used, it's not taxable. So it's a very tax-efficient, tax-favored accumulation device, and it also preserves government benefits. So that means now, if you're on SSI, you can go up to $100,000 in an ABLE account. So your means test goes from $2,000 really to $102,000 because you can park excess funds in the ABLE account. They come with debit cards, so it's easily used, good administration, and it's just a nice component piece of the overall plan, financial plan, when in conjunction with a legal plan, gives you great flexibility as either a spend account or an accumulation account. If you've got somebody who is not on SSI or beginning to work, there's also employment income from the individual who's working with a disability can put up to an additional $13,590 of their own money. It's all after tax, but they can put it in as an accumulation in a tax-favored device. And the law allows you to actually now move monies from an S&T, from a special needs trust, into an ABLE account, subject to the limits of the $17,000 a year, because of the flexibility involved. The law now also allows you to move 529 college plans into an S&T, at least through 2026 you can do that. So there's a lot of flexibility there, but the biggest flexibility inside of ABLE is that you can use it for housing related expenses. And technically, you're not supposed to use a special needs trust for housing related expenses because it's for supplemental needs. So we see ABLE accounts being used to pay taxes or maintenance or even rent on different aspects of housing. So that's why it works so well in tandem with a special needs trust. And it's an area that everybody should consider. Most of them have very, very low minimums to open an account. If nothing else, open the account. Then if some money's come in that you can't get spent down or used through quickly enough, you can park it in ABLE accounts. You still have access, and you're not going to run afoul of the means test. So all of these things that we're seeing here, the special needs trust and the ABLE accounts, all protect government benefits and provide with less restriction overall what you can do with the various different funds. A lot of material. I know it's between the trusts and ABLE and everything else I'm talking about. It's kind of a dump of a lot of information, but all very important. We talked a little earlier about guardianship. Again, this isn't a must. It's an issue of consideration depending upon the situation. And it just depends on what that situation is and the capacity of the individual. But today we see when guardianship is used, rights are left in place, more protections are put into play. Courts are pretty specific around not wanting guardianship if it's not necessary. And then last, of course, identifying care providers. What's going to happen if something happens to the primary caregivers and what that situation may be. Has it been discussed? As I said, has it been communicated? And that's going to be the important piece going forward to make sure that everybody's on the same page. Last, we talked about in depth this letter of intent. We have a computerized version, digital version that you can fill out that easily can be changed. There are many different variations of this through legal law firms and different people. A lot of nonprofits have it. Again, it's to capture as much information of intent of what's to take place in the snapshot of everything that's going on. And it's good for the family to see it, review it, all the way down to simple things like hobbies, what they like, the dislikes, all these kinds of things can be there. And it's going to help in the overall lifestyle in future generations of what this individual's life is going to be and what's it's going to be involved. Not that other things won't emerge. And that's what's nice about the letter of intent, because it's not so much a fixed legal document. It's a document in progress all the time. So as we go through these various different things, you see the integration, the importance of communication. You see the issue of the legal documents having to integrate with the financial information. It's a lot of things that need to be done on an incremental basis. It's not something you can, one and done kind of thing. It's a constant thing to make sure it's up to date. Is it still accomplishing what you want to accomplish? Has the situation changed from employment or housing? So whenever there's a major change like that, things need to be reviewed to make sure that we've had simple things like an employer will change companies that they're working with for some of the fringe benefits, but people will forget to go in and make necessary changes. So because it's not static, we have to stay on top of various changes that are taking place and what may happen. Again, I talked about the 2 attorney groups. I talked about the designations. Find people that specialize in this, that really understand it. People that, if you're approached about a boilerplate plan, whether it be boilerplate legal docs or boilerplate financial plan, each plan is individual. The plan should be about you, your family, all those involved, and should be very specific to the needs, the desires, and want and vision of that family unit. So working with the appropriate professionals that will work with you on that basis is going to be critical. And that's where you really start the process. If you haven't already, some people have done pieces and parts, and that's great. And so we are, we're always looking to make sure that, are you where you want to be? Does it need to be adjusted or tweaked going forward? At Mass Mutual is not the only company out there. But we have specialized planners, and we have nonprofit partnerships. We do speak at a lot of the large organizations, conferences. We can introduce you to the network because we maintain a network of special needs attorneys through those 2 groups, and actually attend next week. I'll be at the Stetson University, which is the CE meeting for special needs attorneys, and just have some great workshops of the currency of what's going on. So all of those And then we can help with a variety of what you might fund a trust with and the integration of the financial issues. It's all about lifetime of care and a lifetime of needs, but more importantly, always quality of life. And so what we're after is the maximal level of quality of life and building capacity and capability so that you can feel good about what's taking place. It's not just the documents, and it's what they accomplish with the vision. It's what they can do to create that lifetime care and quality of life in the process. So with that, I'll stop. And anybody has any questions, they can address it in the chat or whatever, and I'll answer what I can. You see my contact information there. We're happy to, like I said, I'm not charging fees per se. If you have questions, feel free to email it in. We'll answer them. No obligation. We're here to basically do everything we can to help provide a resource. But Nancy, I'll turn it back to you.
Thanks, Jerry. Having been through this process myself, I know that's a lot of information to digest. From those of you on the call who I know, you're in the midst of this, one point or another. Maybe others haven't started yet and are really at the beginning stages. What questions do we have? Jerry, I have a question. How do you know if you absolutely need to contract for the services of an organization like yours? And then the question will become about the cost.
Sure. I think that one of the first questions I would ask of an attorney or a financial planner or anybody, can I do a consult with you to discern the need at no cost? And so without obligation, you're able to at least visit for an hour and just kind of outline your situation. And then it's really up to you as an individual, because you're either going to feel good about it, comfortable with it. You don't want to be dealing with somebody that you're not absolutely comfortable with. So I think that's the first thing. And most of the attorneys we work with do an initial consult. And in our case, we do an initial consult of that. We've got two models. One's more of a formalized financial plan. The other's more of a walking through the process, because we end up in many instances where they'll have to buy different products or something. And I don't want to charge fees in addition to that. So we just explain the process, explain what we're going to go through, do some of the same things I just did today, and then help the individual decide, is this appropriate? And is it something they think they need? And here's our models, and here's what the expenses will be. I think many times, too, we hear that, they're afraid to go to an attorney because of the expense. So ask those questions. It is not inappropriate to say, what are your fees? Do you work on an hourly basis? Do you work on a planned basis? Can I call you and not be on the clock? Kind of thing. So openness and honesty to what it is. If the person you're talking to is not responsive and making you feel like they care about your situation, then you go to somebody else. It's that simple.
Great. Thank you. Kate, your question?
Hi, I'm Nancy. Thanks for hosting, and thanks for your presentation, Jerry. I'm curious, we saw a presentation from the ARC of Northern Virginia about their special needs trust. Is that considered a pooled trust? And
yes, the ARC in Northern Virginia as a pooled trust, and it's kind of a classic pooled trust. You sign a joiner agreement. I think they have some minimum funding to start with, and it's managed with other monies of all the people in the pool to get institutional management. The ARC of Northern Virginia have a lot of services that they also provide that go with their pooled trusts. We generally see it though for those that didn't want a standalone trust or the assets were not significant. Most pooled trusts will require some initial deposit, whereas most special needs trusts stand alone. We encourage that we not put money into it. We only point assets in the direction of the trust. The reason being that if the trust is generating income, think of it like a person. If it's generating income, it's going to be taxed at trust income rates, at trust rates, which are higher than personal rates. So that's why I would rather have a life insurance policy or a brokerage account on the demise of the individual's point to, through a TOD or beneficiary arrangement, to the trust, so that the trust really becomes more activated on the demise of the caregivers. That's probably
helpful.
More than you needed. But anyway, yes.
No, it's helpful. Thank you. I appreciate it.
Yeah, it's a pooled trust. There's another one in Richmond, and I think there are a couple also in Maryland with the different groups. They're always going to be tied to a nonprofit. Any other questions?
I'm trying to be patient here. It might take a minute to like just even formulate a question given the extent of this information.
I've tried over the years to make it as simple as possible, but it's just a download of a lot of things. And that's why you got to get with someone that's going to help you walk through the various different processes.
I mean, I have a question in the meantime. So, you know what, the slide where you talked about the entitlements versus the public assistance programs, are all of the entitlements tied to not having gainful employment?
The entitlements of the Social Security system itself. So that basically includes gainful employment for those getting eligibility. The one benefit, the childhood disability benefit, assumes that that child cannot have gainful employment. So that's the one benefit that affects the child or adult child based on the parent's earning record.
Yeah.
But if I've got a young person with a disability who's working, they're in the Social Security system for themselves.
That's right.
So they may even qualify for an SSDI or Social Security disability benefit from Social Security on their own earning record, which makes it that much more confusing, right? Because
very confusing. Yeah, we just went through that with my son, the switch from SSI to SSDI. I'm like, what are you talking about?
Right.
Took a lot of hours online with SSA trying to get some information.
Well, what is even more confusing, you could have somebody, because they're not making a substantial wage, but they're making a good wage, that might get a Social Security disability benefit under the Social Security entitlement system on their own disability. They may still be getting a little piece of SSI. They may be in Medicaid, and they may be on Medicare, because after 2 years on a disability, they could be on Medicare, and they could be in their parents' health plan. So, it's not also either or. Sometimes it's all of the above.
I think what I want parents to understand, though, is that, a lot of this, I think the way you're presenting things, Jerry, is like how to absolutely maximize every single benefit and every single penny, that you're eligible for. But over time, you can develop that kind of a relationship with benefits and special needs trusts and a legal system. But for most parents, you can start slow. You can just, you can apply for SSI and Medicaid and start there and then build this stuff. So don't be intimidated because you don't have the entire picture in front of you now. In fact, you never will, which is why we rely on financial planners to be able to support us in these kinds of things. But even if you can't, you can still apply for benefits, get your kid where they need to be and be good, responsible parents.
It's a great
over
point.
time, find your way to all of the nooks and crannies of the systems.
Well, and I think some of it requires some prioritization. I mean, you could spend more time on this than caregiving itself.
That's right.
So it's part of that is, what's most important, being aware of what's there. You're not necessarily also eligible at any given time for everything. Mm-hmm. But when we go through it, we don't know whether you have an adult child, a young child, or what the situation is. So we're having to just kind of open up Pandora's box, but it is overwhelming, no question. But that's why you want to work with somebody that can walk you through the process and help you through the process.
So what are the other questions? There have to be other questions or else you're just totally overwhelmed. One or the other, because this is difficult. So do you recommend a particular age or what's the turning point where people have to turn this thinking on, Jerry? Anything? Let's say they aren't going to when kids, especially kids with Down syndrome, are born, lots of times there's lots of health issues and you're trying to figure out the educational system and you haven't gotten to all of this yet. So if you're in that situation, when do you tell people really put your, let's move on with this, you really need to get busy with this?
Like you said, following a diagnosis many times, you're kind of overwhelmed with the situation and what does that mean? So you're generally going to know as you get involved with various programs, you've gone through early intervention or you're the IEP process. I mean, we advise people, the better prepared they are for their first IEP, the better the overall result's going to be as they're going through the school system, because it's hard to add to it as you're going if there wasn't an overall plan for development. So early intervention, IEP process, we'll focus more to help and provide a resource there. We see a lot of people, we hear from a lot of people as the child is entering transitions and they're beginning to see they're going to be coming out of the school system onto their own. And it could be some school systems trying to graduate them out in a normal sense, 18, 19 years old. Some are saying there's going to be programs through age 22. Depends upon the system, the child. So, but we hear a lot around that. We hear a lot from people when they're getting close to age 18, because they know that's a critical age when they're going to have to look at, potential for situation around guardianship or caregiving and what's going to be that, as well as SSI coming into play and Medicaid coming into play. So that's probably one of the times when we get as many calls as any is as they're reaching the transition area in school, and they're starting to look to post-secondary school, and what does that mean?
And Jerry, there's a question in the chat. Can you have a 529 and an ABLE account, and can both roll into the special needs trust?
Okay, 529s. Well, let me correct that. The special needs trust, you can roll from monies out of a special needs trust into an ABLE account. Okay, not the other way. So you can't go from ABLE to a special needs trust. The law now allows us to move 529 college funds into an ABLE account, subject to the annual contribution limit of $17,000. Money coming from an S&T to an ABLE account is subject to the $17,000 limitation. Now, can you have both? If you've got a plan that allows you to change beneficiaries between children or other people, then that's the more traditional 5 plan. Social Security does not count that, because you can change beneficiaries, does not count that as an asset toward the means test. So for that reason, we do have people that have 529 plans where they're accumulating funds, and they also have ABLE accounts. Now, if we found that they're not going to be able to use the 529 for whatever reason, then that would be a good time to strategically look at moving monies from the 529 plan incrementally over, if it's over the 17,000, incrementally over to the ABLE account to give you more flexibility on what you can spend those funds on. But you just got to make sure you've got the right traditional 529 plan. Prepaid college plans for a particular university count as an asset. It's a particular child, a particular university, particular amount. Can't be changed. Those count toward the means test. So that's, again, another example. They do their best they can to confuse us, because not all college plans are treated the same way, but the traditional 529 plan does not count toward the means test. So you could see both.
Wow. Okay. Well, Jerry, our time is up. Thank you very much. I ask all of our participants on the call tonight to please fill out the survey that I've linked in the chat. This was a lot. Thank you so much. We really appreciate your expertise and appreciate the support that your organization has given to us over the years.
Very good. Very good. Thank you very much. It was a pleasure to see everybody. Take care.
Thank you.